There's, of course, Jussie Smollett. We thought it was over. Did you think it was done? I thought it was done. We all thought it was done. We thought he was gone for 5 months, and now no, he's not.
There are a couple of things, like for the appeal, like, my honest opinion is, even if he doesn't get any more time other than the 6 days, I think that's good enough for a false police report. He spent a week in prison or in jail. If someone, I don't think that's I think that's enough jail time for that crime. You know what I mean? Level 4 felony, no violent criminal history. Okay, he's spent a week in jail. So, but people wanted to spend like the whole 5 months. They want him to spend the whole 5 months in prison. So I don't know. I don't know.
You know who wants him to spend the whole 5 months there is this guy right here.
Kurt.
Years.
Mr.
Years.
Oh, yeah, your volume. Kurt, can you turn your volume down a little bit? You're popping a little bit.
Yeah. Welcome to another episode of StreamYards and You, the microphone wars.
Who's winning?
I unsubbed from StreamYards for their premium service. They sent me an email saying why. I sent back an email. I let them know. Your audio method sucks.
Was it a dissertation?
It might have had the words unbreaded a couple times. It's possible. No,
unbreaded.
Yeah, I think I have to respectfully and quite poignantly and dramatically disagree with my good friend Nate the lawyer on this one, because every crime is, of course, measured by its own terms, as it should, as it must be, right? Justice is and must be a individualized exercise, because not all crimes are created the same. And so when you look at this particular crime, according to guidelines, probation is to be recommended. I have no problem with this recommendation. Now let's look at the particulars of this particular crime. For my mind, the fact that he tried to start a race war is kind of important, in my humble opinion. This is not, in my humble opinion, your average lying to the police, obstruction, wasting their time stuff. Mm-hmm. This, to my mind, I'll go once. I think it is a crime of violence to some degree, because there was a fake hate crime with violence, and the violence might have been committed against him, but so what? And also, I think you can go to an attempted crime of violence, because again, race war. So, trying to turn the entire city and country apart. So in my humble opinion, a weekend penalty does not justice in this particular case make. I was like trying to do the calculations on like, these are separate crimes, which means consecutive. What's 3 times 5 again? Oh yeah. But I was not getting anywhere close to anything
15.
like that. So yeah.
Yeah. I'm with you on this being
split the difference on this 3-judge panel.
Yeah, I'm with you on this being kind of a different kind of case, right? Because of the fact that this is not just somebody who is making a false report, to the police, which should be punished, regardless of who it is. But this was somebody that was purposely doing it in order to benefit himself and to start, something nationwide. And I think that it's the level of attention that he intended to get, and then, purposely did get for it. I think is one of those things that really should be a factor in this. That's not your average situation.
I mean, even if he didn't intentionally, bare minimally, he knowingly. He knows the state of the world, particularly at that time, about what is going on in race relations as America, which, as we might remember at that particular moment in time, felt particularly fraught and particularly on edge at that particular moment in time. He knows that. He's not a complete idiot. He's aware of all those things. So he does what he does in knowledge of that. Mm-hmm. So the fact that he has that knowledge is a sufficient mens rea, to my mind. Whether or not he intentionally exploited it, which I think you can get there too. Mm-hmm. Is like he did it at that time for that purpose of bringing attention to himself. I'm still convinced that the letter itself, the letter that started this whole rodeo, was probably fake.
It was him. Yeah, of course.
Probably was him.
Yeah.
And it looks like an arts and crafts.
And I'd like to just remind
project.
everyone at this point that mail fraud is in fact a federal
He would
felony
have got more
that I
time.
believe can get you up to 25 years under
Yeah,
certain
he'd go.
circumstances. So I just want to say that, make me U.S. attorney and we'll make America great again.
Well, hold on. Only reason why you got to be careful with the mail fraud because Lori Loughlin and those people were charged with mail fraud, and they could have got 25 years. They only got 2 weeks, right? And theirs was just as egregious, and they were actual victims with theirs, right? People who couldn't get into the school because they took places on the rowing team and that type of thing. So
you're telling me that the
I
feds
don't know
are
if I would
also
give them.
the feds are also weak.
I don't know. Yeah, but I
Feds
think
are weak. Let's go commit some mail fraud.
I don't think giving people jailed. I think jail time is appropriate. And to be honest with you, in the Jussie Smollett case, I thought jail time was appropriate. Yeah, I do think, and I think the judge can easily get there. But if someone says, he spent 6 days and we're not going to, and that's going to be it, I'm okay with that, right? He's still got the probation and all that stuff. But I don't think, I think a year or 2 years or something like that, I think that's just too much. Just as somebody who's
going to be a Lifetime movie, My 6 Days in the Hole, the Jussie Smollett story.
So what do you guys think is going to happen next as far as the appeal is concerned? Because people are asking, I know you guys talked about this yesterday on Nate's channel, just as kind of like a quick response to it. But have you guys thought further on this?
Well, I got a video coming out later today about this. But one thing though is that the Jussie's defense team, and this is me playing prosecutor now. Jussie's defense team is trying to kind of have it both ways. And what I mean by that is now they're coming and saying for the appeal, we had a deal. That deal was 2 days community service, $10,000 fine. We had a deal. And the prosecutor made that deal. And we don't care if the prosecutor was authorizing anything. We had a deal. We did our part of the deal. And the prosecutor should be held to that deal, right? That's what they're saying. That's what they said last night. That's what they said in the last day of court. But I actually went back and looked it up to see if they've always been saying. So right after Jussie did the deal with the prosecutor initially, I have the clip even ready. This is what the defense team said about whether they had a deal with the prosecutor's office or not, and whether he committed 2 days community service based on that deal, and whether he forfeited his bond based on the deal. So we're going to hear his defense counsel, the same one who was in court, all these people, right? The same defense counsel. She's going to tell us whether Jussie Smollett had an agreement with the prosecutor to do all this. Exhibit A. Here we go.
All right.
StreamYards.
Come on, StreamYard. it was like perfectly set up, and then
StreamYard.
Let us down again.
Oh, there it is.
Here we go. All right. So now we're expecting her to say, yes, of course, we had a deal, right? And this is let's see what she says.
No, the discussions were strictly with the prosecutors who were actually handling the case.
Now, the prosecutor's office says that the charges were dropped in exchange for your client's agreement to forfeit $10,000 that he had paid in a bond and to do community service. Is that correct?
So now, the question has been asked. So now we're going to know, is this correct? What did you have a deal? And was it, this quid, you do this, I do this. Let's hear what she says.
Those conditions on his dismissal of charges?
There were no conditions, and obviously there was no plea. There was no agreement in place. They did want him to forfeit the bond, and that's something that we discussed with him, and he initially struggled with because he didn't want the perception to be that he had done anything wrong. But at the end of the day, forfeiting $10,000 versus putting your life on hold for a year was a small cost to pay.
But to be clear, because the prosecutors are now trying to say, well, there were conditions. This wasn't a get out of jail free card. You're saying he chose to forfeit that bond essentially voluntarily.
Yeah, they had asked if he would do that, and we advised him that he should do that because it was going to cost him almost, multiples of that number to go to trial.
What about the community service aspect of it?
The community service is something we initially raised ourselves at the initial bond hearing, saying this is somebody who's volunteered hundreds of hours, thousands of hours since he was a teenager to all sorts of organizations. It's something he's always done. So in our discussions with the prosecution, we told them about his volunteer service. We did show them a few letters of his ongoing community service.
But was this a condition of the charges being released? He's got to do this community service.
He had to do nothing. There was no obligations, no conditions. These are things that he chose to do because that's his character. And again, you can find out from multiple sources that this is what he's done for years and years and years with multiple organizations.
Let's talk about some of the facts.
I'm a damn good lawyer. I am a damn good lawyer. To pull that up right there to prove. Now they're saying that he had a deal, but I've just proved to you that they didn't have a deal. She said they didn't. They never had a deal. So everybody out there talking about, hey, there was a deal. We had a deal. His lawyers are saying they never had a deal. If you guys get in trouble,
Holy.
you better call Nate the lawyer, because Nate the lawyer goes, that's my exhibit 1. She's saying that we never had a deal.
Oh,
No
man.
conditions,
She's
no
like, I have
agreement?
this side of my mouth and I have that side of my mouth, and I'm going to talk out of them both.
But that's what lawyers do, though. I'm inventing new sides of my mouth to talk out of all the time. That's part of my job.
I mean, you know, it's there is such a thing as alternative arguments, but I think this is taking it a little bit too far.
How can you not take that to the appeals court? His own lawyers are saying this on TV. They've been saying this for 6 months.
Ay, ay, ay.
They've been
Is
saying
she,
this for 6 months.
is that lawyer still on the legal team? I don't remember seeing her at
Yes,
the sentencing hearing.
She was. Remember, she's the one that gave the hour and a half speech with the sentencing hearing. Remember the hour and a half speech, that the one where she was. We were all so bored. We were like, oh my god, that was her.
Oh, she looks a little different in this one. Like maybe she's I don't know, hair and makeup or something looked better at the sentencing hearing. I don't, no disrespect to her in this clip, but she just I didn't recognize
No
her.
shade, but she looks like trash.
No, that's not what I'm saying. That's not what I'm saying.
So now Kurt, because Kurt was the one saying this is just like Cosby. This is just like Cosby.
I didn't say
Kurt.
that.
Oh yeah, I thought you were saying. Oh no, I think it was Natalie. Maybe it's Natalie. So, but I'm asking you that I think there's a hell of a blow to their argument.
Yeah,
I think so.
And for anybody that is kind of new to this, question, Bill Cosby, he was sentenced to jail for assaulting women, many women in a very intimate way. And then the defense team came back and ended up successfully arguing that he had been offered a deal by the prosecutor, the previous prosecutor, who was replaced by the one who ended up charging him. He had been previously offered and accepted a deal that's saying that they were not going to prosecute him if he decided to testify in the civil matter, because I guess they weren't planning on charging him or whatever. And then that prosecutor was replaced by a new one who said, nope, we're charging, we're going. And so he successfully argued that he was able to rely on that previous promise, and so was able to get out of jail a little bit early. So anyhow, Nate, I interrupted you. What were you going to say about that?
Yeah, the Jussie Smollett case turns on, I think, a different question. I think Kurt said it so eloquently last night on his stream, but it turns on a different question. The Jussie Smollett case turns on the authority of the prosecutor to make the decision to dispose of the case. When the prosecutor in the Jussie Smollett case when the prosecutor recused herself, she essentially recused her whole office, because the office, all the other ADAs under her, only had authority through the prosecutor. So she delegates authority to them and they prosecute cases. That's the way it works in Illinois. But so when she accuses herself, then a special prosecutor has to be appointed to regain that authority to prosecute cases on the state's behalf. So what happens in this case is that the state prosecutor recused herself and then appointed her subordinate as an acting state's attorney. And that's a fictitious office. There's no such thing as an acting state's attorney. There's absolutely no this. So they had absolutely no authority to come to any agreement with Jussie Smollett. So what did they do? They came to an agreement with Jussie Smollett, which now his attorneys at the time said they didn't come to any agreement, right? His attorneys said there was no agreement. They're saying they came to an agreement. So the legal issue that came up in this case was, well, if the state's attorney didn't have any authority to come to that agreement, is the agreement still valid? Does the agreement hold? Now, Jussie Smollett and his attorneys are saying, well, yeah, the agreement is still hold. Number one, we didn't know that this is going on. And the fact of the matter is that there's an apparent authority here. They went to court. They said, I'm the state, we represent the state, and they cut us a deal and we served our part of the deal. So it's on them, not on me. Mm-hmm. But there's some case law that we looked up yesterday. I was showing Kurt, in which the same exact thing happened in the past. And the court has reasoned that that whole prosecution is void is void on its face. You don't even have to go to the court and ask the court to void it. It's void on its face because the only way the state allows you to prosecute citizens is by having that authority out of the statute. So in one instance, the court is saying, well, that was void, and that's what allowed the second prosecution of Jussie Smollett to occur, because there was no statutory authority for the first prosecution. So we're going into appeals with those two arguments. Did Kim Foxx's office have the authority to prosecute? If that answer is yes, then Jussie's second conviction is probably likely going to be overturned. If it's no, then his second conviction is likely going to be upheld.
But then there's also the additional question that we kind of just went over with that video clip, is whether or not his attorneys actually believed that that was a valid offer that they could rely on. Because it sounds like they didn't have, I mean, they're walking around saying that they didn't have an agreement. It sounds like they didn't take that as a real offer, right? So that's another potential argument for the state to say, no, we don't have an issue here.
Yeah, when you have the attorneys, so the clip, you just came in, boss attorney, we just watched the clip of Jussie's attorney right after they dismissed the charges. They said there was absolutely no deal. We had no deal. They said, well, what about the $10,000? He said he gave it up voluntarily. What about the two days of community service? He said he did that on his own. Right, there was no deal, no conditions. They just dismissed the case free of charge. So there was no conditions on the deal. So his attorneys said that then. 3 years later, now they're in court saying, guess what? We had a deal, and we want the deal to be upheld. But this is like, well, hold on, you just said you didn't have a deal. Now you do have a deal. So that's what we're saying, that may compromise their position, because if I'm the state, I'm like, well, here's, and she went on CNN and said it. She went on ABC. I have tons and tons of her saying this same thing, because she went and did like a press tour. So, I'm assuming the state attorney is going to say, look, now they can't sit there and argue that there was no deal. And then now all of a sudden, because it's beneficial, now argue they have a deal. Now, obviously, there's a difference between the factual arguments and the legal arguments, because as a matter of law, the court can still find, well, you had a deal as a matter of law, which I think would be the saving grace here. But I think it's hurt their case for them arguing that there was never a deal. And now they're saying there is.
Yeah. Well, it'll be interesting. Do you guys know how soon it's likely that we'll hear another iteration of this whole saga?
Well, now it's just up to the appellate court. He's out. He's going to be chilling. He's probably going to do some press. So he's probably I'm assuming he's going to be out.
I'm sure he's going to do some press.
Yeah.
I feel like that's the most certain
How can
thing.
he not do press? How's he not doing press right now?
Another sit-down interview, talking about how the world is unfair to Mr. Jussie Smollett. So. Yeah. Oh man.
We videotaped the rehearsal, man. I mean,
videotaped the rehearsal.
What more do I need? He videotaped the rehearsal.
I know.
That's a lot of evidence.
I know.
But this is a matter of law, though. This is not about the facts. This is about the law. If they had that agreement, legally it's over.
You know, everyone has their blind spots when it comes to being unable to put aside biases, and this one might be mine. I try to be fair. I'm not sure on this one I can be. Yeah.
With that being the contract, Nate the lawyer, for an implied contract, doesn't it have to be that a reasonable person has to believe it? And if they're saying that they didn't believe it was an agreement, that can be held against him, right?
Yes. I think it can. But in this case, when you read the statutes, it's very specific. To be able to prosecute someone and remove their rights on behalf of the state, you have to be authorized by state statute to do that specifically. Yeah. And the only persons authorized by state statute to do it is the state's attorney. Now, if the state's attorney recuses themselves, then a judge can order a special prosecutor, like he did in Jussie Smollett case, to take up, and that person would have all that authority. So it's just like, I use the analogy, it's just like anyone, right, going into a courtroom in a suit and tie. I might even be an attorney and go stand in a prosecutor's well and say, I'm representing the state, and then dismiss every single case that comes up. And later on, they'll, then somebody will come and say, "What authority did you have to do that?" And I said, "Well, I'm just some guys, and everybody, even though everybody believed that I was a state prosecutor at that time, it'll come down, did I actually have authority? Was I hired? Did the state prosecutor delegate that authority to me? And if I have no statutory authority to make those deals, then the court says those deals are void ab initio, right? They're void on their face. So it's not like you even have to go to court to void those deals."
Yeah. Right. Makes sense.